look forward very much to having, you know, Lebanon County join in this process. You know, it's the state. What we would propose first, if you do sign the contracts, would be to file a writ to stop the the tolling of the statutes with regard to the old act that we would be operating under. I know that the county is interested in, the first step would be to be sending a letter out to the telephone carriers to request their cooperation, which I actually have a copy of what one of those has looked like in the past.
I think I forwarded.
Oh, did you? Oh, okay, great.
Great.
So, you know, it's, you know, it is, we really have had no success with that letter, and we can, you know, show you what the responses are that we've gotten. I can share that with Jamie. But we're happy to go down that path if that's, you know, a preference.
You did that in, I think, what you said in February, you did that in Berks County, for example.
We said that
you had an opportunity, and you had one or two.
We had one. There was really only one carrier that got back to us. Technically it was two because they had merged, but it was really only one, a very small carrier that actually had gotten back and said they'd like to cooperate. Delaware County actually, although they didn't send letters out, you know, we're in the process through the press and all, had offered to the carriers, you know, that if they would show us their line counts and accurately allow us to, you know, look and in effect audit the process, that, you know, that Delaware County wouldn't sue and the telephone carriers didn't cooperate. So my guess is that there won't be any cooperation from the carriers upon that request, but, you know, if you guys would like to try that approach, we're not, you know, going to say no to that.
Would you address for a moment just what the cost, not really the cost to the county, but essentially how you get compensated if there is a recovery?
If there's a recovery, you know, from a carrier, there would be a 40% of that recovered amount would go to the team of Dilworth Paxson Law Firm and Phone Recovery Services. The way that 40% is divided up depends on how much litigation actually occurs. As time goes by, more, you know, if we can do this without litigating, where the phone carriers will allow us to do an audit where there's a lot of work on Phone Recovery Services part, Phone Recovery Services gets a bigger piece of the 40%. As you move into litigation, the Dilworth Paxson Law Firm, where most of the expense will lie, would get a bigger piece of the 40% recovered amounts.
And for your information, I did provide this to your solicitor, Dave Warner, weeks ago, and had a chance to look over it. I don't know if you have a remark to that or any comment.
No comments as to the form or substance of it. I mean, barring the percentage rates or terms or anything like that, you guys might have a question.
This is, the contracts that were supplied are very close to the ones that have been used in other counties, with some minor changes from you know, county to county. But the percentage has been the same in all the 16 counties.
First of all, is it your percentage based on the amount they actually owe, on the amount that's actually collected?
It's the amount that's collected.
Okay, that was question number one. And then I guess the next question is, I had sent some questions and I don't remember receiving answers to them directly. Maybe they didn't go to you.
Yeah, I don't remember. What I'll tell you is I'm happy to answer them. You know, if I can now, I will. If not, I'll be happy to respond in writing.
Right.
Yesterday there were some that were sent around.
No, I'm talking initially, back in March 1, when we had a workshop.
If you have them, let's just go through.
Yeah,
them.
yeah. I mean,
Sure.
see if I can, and if not, Melanie,
Okay.
take some copious notes here.
Okay, at the presentation, I heard PRS would audit 2 to 3 years, and that future years are optional. The contract, however, says 6.5 plus an additional 2 years going forward, so that's a total of 8.5 years.
Yeah, what we're going to be doing is, you know, we would be trying to go back as far as 6 years. Okay, I'm not sure that the statute of limitations arguments that Dilworth will make will allow us to go back and collect as far back as 6 years, but that's what we're going to try to do. The minimum that we can go back and collect is, we believe, 2. In the contracts that you have in front of you, there is the thought of a prospective, you know, follow-up by Phone Recovery Services and Dilworth to make sure that even after we've done recoveries and we've collected monies for the county, that, you know, to make sure that the carriers are in fact behaving better. You know, and, you know, what I'll tell you is that is, for instance, one of the areas where, you know, we've been willing to remove that section. You might not want us to help you in the future. You might need our help in the future. And honestly, it's going to be more difficult to follow that now that there's a new act in Pennsylvania, because the collections going forward are governed by the act that was passed in August of last year, and all the collections are done at PEMA. So, you know, frankly, it would require PEMA's cooperation in that effort anyhow. So, I mean, look, we're not, I'm not sure there would be any effort in the going forward, and if you wanted to remove that section from the contract, we'd be happy to.
Okay, because, I mean, I didn't think that was part of the deal. I was looking to do the writ and the letter because I was always brought up.
Yeah, and I think what I said, which I agree, is that we won't do that unless you want us to. And the contracts that were sent out were just kind of boilerplate contracts that we had used in some other counties. So, I mean, we're happy to remove that.
I was brought up to believe that first you try and negotiate and you try and avoid court, okay? And so that is why I would like to see the letter sent, number one. But number two, because you do have a record of accomplishment, you may be more successful than you have in the past with that letter.
We're willing to give it a try. I mean, we certainly are. We actually have had a couple more settlements too since we were in here, but down in Alabama anyway. I mean, AT&T settled for out in Alabama. I can't tell you how much it was because there's an NDA there, but it was, you know, significant. Under $1 million, but significant. And Verizon is settled in Birmingham now as well. So, you know, we're pretty sure we're going to get to these guys. It's just going to take some time. But anyway, I'm not sure I answered your question or avoided it.
My next question is, and this would be a Dave thing probably, does a contract or an engagement letter carry more weight?
Meaning just what these two agreements are being called, they're the same thing. I mean, really, it's just a different term for the same thing. I mean, some attorneys or firms call it fee agreement, engagement letter. It's all the terms of the contract.
It seems to me that the percentages listed differ between the two documents, and that's why I was asking.
I think they balance each other out.
Yeah,
to
it's
total up to a cumulative 40%.
right. What the contract shows is that certain amounts are going different places depending on how much work has been done by each of the parties. As Dilworth starts to do more and more litigation, their share of the 40% goes up, but it's always adds up to 40%.
That covers my questions. Thank you.
No problem.
John?
Yeah, so Delaware County is pretty well along.
Yeah, they're moving forward pretty quickly. At this point, there was a tentative court date set for June of this year, but the phone carriers have already requested that that be extended. You know, I think that, you know, at least based on what Dilworth tells me, that we're looking at maybe a court case starting in December or November maybe.
Do you have a sense of what you might be able to collect in Delaware?
We do. In Delaware County, we think that, at least based on our estimates right now, it's somewhere around $8 million a year in shortfall that Delaware County's been suffering. I mean, it's a bigger county with more businesses. And we're now into sending out discovery. Okay, as we actually get discovery from the telecarriers, we're going to really know what they owe.
Can you explain the advantages to kind of doing this? It looks like a piecemeal rather than identifying. You mentioned a couple of the big ones and kind of going in as a collective with the counties left.
Well, there's, you know, for instance, like a class action suit
Yeah,
sort of
in other
thing.
words.
You know, we looked at that, and there's a couple of problems, and, you know, just to name a few, you know, one of the things that we looked at is each county under the old act had a separate surcharge. You know, so it's difficult to have a class when everybody's charging, their surcharge was supposed to be different. The other thing that's difficult is that, you know, and I haven't really talked to your 911 director yet, but I'm guessing there are 25 to 30 carriers in Lebanon County, okay? Probably a third of those aren't in Chester County, aren't in Clarion or Cumberland County.
Right.
So it's, again, difficult to have a class that captures all the damages you know, when, you know, yeah, you probably got Verizon in every county, okay? You might have AT&T in every county, but you don't have Charter and you don't have some of the others. So that was another part of the reasons. And the other thing is we also strategically think that if we've got a lot of different complaints going on at the same time in different counties, it puts a lot more pressure on these carriers and their legal teams. Now they got to fight it in 16, 17, 20 counties, you know, which is, you know, more expense to them, more pressure on them to come up with a settlement. So, I mean, there were reasons like
Makes
that.
sense. Just want to clarify, Commissioner Litz, you said that you referred to going along with the letter and the writ. This engagement would engage them to file the writ and the letter, but continue to proceed.
Can we do it
With-
in 2 motions?
I don't know.
Well, I mean, we need to be, we have to have you guys hired for us to file the writ, okay, which you really should do to toll the statute of limitations on losing past damages. I mean, we're not gonna file a complaint until, you know, against carriers until, 1, the letter is responded to, and then 2, we're not doing that until the commission says it's okay for us to file a complaint. Honestly, if you have the writ filed, it probably protects you anyhow.
Well, that's what I was told at our workshop. that
Right, right.
If we filed the writ, it would keep us from losing anything, and it would preserve our time, because the time gets shortened if it goes on.
Correct.
And so therefore, we would be preserving our right to sue, and the letter that goes out would give them a chance to come forward and do the right
But
thing.
we're happy to
And you would
pursue.
still get 40% of what's
It would-
collected.
What makes us happy.
But I wasn't ready to take the step to file the suits.
Yeah, I mean, what happens under this engagement is it allows us to file the suit on your behalf once you tell us to go ahead. I mean, like Lancaster County, for instance, filed the writ, but has decided not to file a complaint. They're just gonna sit on the writ. Now,
That's what I was looking
Now,
to
at
do.
some point,
Yeah.
the court could, you know, say, okay, look, you gotta do something here. You filed this writ, which says that you've got these potential damages, you know, it's been filed in my court, you know, you guys are either gonna have to file a complaint or not. Okay, now that could happen. So at that point, you'd have to make a decision
Right.
to go ahead and file the complaints.
But if we would pass it all in one, it could be automatic, we wouldn't have to take another
but-
vote.
No, we're not gonna come back and file the complaint without the acquiescence of the county. We're not. I mean, if you
But
need,
I don't think you're understanding the nuance here. Would it require a second vote?
I don't know the answer to that.
Well, if you were to, I think the way this engagement is written currently, it would authorize proceeding to that.
That's what I thought.
So you'd have to parse this agreement, I think, to,
Dave may want to weigh in
I
there.
mean, on a practical level, we're hiring the firm and then Dilworth Paxson to be our attorney. I mean, Dilworth Paxson acting as the attorney of the county should be following our directions, and I'm sure they will. So if the instruction to them is file the writ of summons, do not file the complaint until we're prepared to proceed, we can just do that with them on a normal attorney-client relationship basis. And frankly, they'll need the county to sign a verification and authorize the complaint, things like that, just to move forward with litigation.
And would
So-
we vote at that point again?
No, I don't think so. I mean, I think we're retaining them at this time to go forward and pursue this action. Anything else we do can certainly just be handled through Jamie, through myself, through our normal transactions of doing business.
I would respectfully request 2 separate votes.
Is your opinion that that one is sufficient?
I think one is legally sufficient.
One is sufficient, but you can do 2,
To
correct?
retain them. I mean, I guess the only clarifying thing you could put in that initial motion is that they shall only file the writ of summons at this time, or something like that. But otherwise, again, I can't imagine as an attorney that they would pursue further legal action without the client's directed to do so.
so it's a difference between the directive being given by the solicitor or the directive being taken as a motion, I think is what we're down to.
I make a motion to adopt as it's written, to give the authority to these folks to handle it for us.
Is there a second? I'll second the motion. Any further comment? All in favor, please indicate by saying aye.
Aye.
Opposed?
Aye.
2 to 1. Motion carries. John?
One follow-up here, maybe
premature, but based on your experience, do you have an idea of what you might be able to collect for Lebanon County?
Yeah, and I mean, based on our, and look, it's rough,
Yeah.
but we think the number is, somewhere around 900,000 annually in damages here.